Fight for Justice is brought to you by the Kia Store of Anniston and Rainbow City.
Hey, welcome to another edition of Fight for Justice. Tonight's topic is going to be an interesting one on medical malpractice in Alabama. I've warned all my doctor friends and other medical providers that we're going to be talking about this tonight. It's educational. I think you're going to learn some things that you probably didn't know and that are misinformation about medical malpractice cases. A lot has changed over the past 30 or 40 years. We have a special guest with us tonight, Mr. Leon Ashford, who has been an acquaintance of each other now, I guess, for 40 years, something like that. And he's one of the most respected trial attorneys in the state. I've had the privilege to work a little bit with him over the years. It's always fun to watch him work. So, Leon, welcome to the show.
Arthur, thank you for having me.
You're welcome. He is with the firm of Hare Wynn in Birmingham, and they do almost all plaintiff's work, which means that he is chasing the bad guys who cause injuries and accidents. And as you know from our previous shows, we do that as well, but we don't emphasize medical malpractice as much. And if we do, we usually get Leon involved. So, Leon, the name of the show is Fight for Justice. What do you think of that?
I think it is a terrific name. I'm thrilled to be here. I appreciate the invitation.
All right, well, let's get on with the medical malpractice cases. First of all, I think the threshold question in any situation is, what is malpractice and what isn't malpractice? That's where we start when you get somebody who's got a complaint because they got a bad result. Is it a bad result because of malpractice? That's usually the general question. Can you answer that, Leon?
I can start from our law school days. You remember Justice Potter Stewart was asked in some of the obscenity cases if he could define pornography, and he said he could not, but he knows it when he sees it.
That's right.
It's a little bit different for us in medical malpractice cases. We look at almost 1,000 a year in our law firm. We've got 5 lawyers who do a lot of malpractice work. We've got 2 paralegals. We've got a full-time nurse. So if you look at that number of cases in a year, you tend to start with the cases that are not malpractice because those are easy to spot. The time limitation has run. There's just a misunderstanding. There's a question that needs to be answered. And so many hundreds of those calls that come in from people who are concerned. And we try to treat those cases and calls the same way we treat the ones that we actually take or pursue. But back to the point. The point is that generally speaking, it takes a very serious, unexpected result, an injury or a death, to get a family to the point where they would suspect that malpractice might have occurred. And so when they come to us, we don't have any way of knowing exactly what happened. I often tell my doctor friends that I'm their best friend when it comes to litigation and to knowing that if we take a case, that it is a case that should be looked at and pursued. But when we get involved early on, the real criteria, the line, the bar that we have set it involves a mistake, a problem, an error, omission, an act, something that almost any reasonable person would recognize is out of the norm. And then everything else has to be looked at in that context.
You mentioned limitations. You're talking about the statute of limitations, and would you tell our audience how long you have to bring a malpractice case?
Generally speaking, all adults have 2 years from the date of the malpractice, and the statute of limitations begins to run on the day of the occurrence. For instance, if it's a case that involves surgery, it's the day of surgery. There are some exceptions. There is a drop-dead 4-year statute of limitations. And so the only way to get from 2 years to 4 years is if you do not know in the first 2 years that you have been harmed or that something has occurred that relates back to the date of the malpractice. So in no event in Alabama can you file a medical malpractice claim longer than 4 years, with this exception. Any child, any newborn child has until their 8th birthday to bring a claim. So for the parents out there who might have a child that could be or could have been harmed as a result of some act inside that child's 8th birthday, they have a longer period of time to act, and that statute has been upheld by the Alabama Supreme Court.
You mentioned a minute ago that your firm looks at over 1,000 cases per year.
Per year.
And you've got staff who filter through all these voluminous medical records. And as you know, I've just sent you one with probably close to 1,000 pages in it.
That is correct.
How many of those 1,000 that you look at a year actually result in claims being pursued either informally or suits being filed?
I looked this morning to give you an idea about the last 12 months.
Okay.
We filed 9 cases in 12 months. We have 15 cases that are being pursued short of litigation, depending upon which hospital or doctor is involved, what venue is involved. We may be able to have discussions where we resolve a claim and not a lawsuit.
By venue, you mean the place of the occurrence?
I mean the place where the act occurred. Yeah. The legislature in Alabama has written a statute called the Alabama Medical Liability Act that protects doctors and hospitals in this respect. They have to be sued essentially in their backyard. So an Anniston doctor would be sued in Calhoun County. An Anniston hospital has a right to have the case brought against them in Calhoun County. And the only real divergence from that involves actions that might have an act of malpractice in Mobile County and an act of malpractice in Jefferson County, and there's a possibility now that that can be combined. But generally speaking, we look first at venue. We literally look to see where the act occurred, and then we look to see if we can have that case come up to and meet the criteria that we've set.
Okay, we have about 30 seconds in this segment left, and want to take up in the minute where we left off with the number that you turned down.
Okay. The number I turned down is well over 95%.
Okay. Is that true, you think, in most plaintiffs' law firms that handle malpractice cases?
I hope it is, because I think what is happening now is that the cases are being directed to and handled by people that know what they're doing.
Okay. All right, we have about 10 seconds left in this segment. We'll be right back in a few minutes with Leon Ashford, who's going to continue our discussion about medical malpractice cases. See you in a couple of minutes. Welcome back to our second segment. I'm Arthur Fite. With me is my son and partner Freeman Fite, and our guest Leon Ashford from Birmingham, who we've been discussing medical malpractice cases. He's told us about the number of cases he looks at a year, or his office looks at a year, and how many are turned down. What do you do, Leon, with the people that you turn down and won't take their case?
We have to remember that these people have questions and concerns, and they deserve answers. So every case from Hairwind that is turned down involves a written explanation that that client can read and understand. It addresses hospital records many times. It addresses their specific questions most of the time. And again, for my doctor friends, we give them a basis to close the file in their own mind and not to go looking to someone else to try to get a different answer. We actually think that we are doing a service not only to the medical profession, because most doctors, most nurses, most hospitals do good all the time, but they're human beings and they make mistakes. And the clients that have questions and concerns deserve the same sort of respect that we give the medical profession. So if we do a good job of evaluating those cases, hundreds and hundreds of cases, and giving those clients an opportunity to feel like they've done the due diligence that their cause or their case deserves.
Well, let me ask you this. We run into this, and I'm sure you do a lot more than we do, but somebody has suffered a particularly bad result.
Sure.
And they think it has to be from malpractice.
Right.
What do you tell them?
what we say is this: most of the time it's not. Most of the time it is not malpractice. Let me give you the perfect example. We live in a country where 3 or 4% of all hospital patients who go in and have an invasive procedure now come out with a hospital-borne infection. That's a large number of people. And in Alabama, there is no way for us to say to that family or to that person that they have a case of malpractice, because we don't know where the infection comes from, we don't know how it got into them, and it just is not a case that is subject to being brought in Alabama. That answer needs to be delivered so that they don't then go to 2 or 3 other law firms.
I can tell you from my own personal knowledge that the major hospital here has an infection rate of well below 1%.
Of course.
And we are striving every day to meet the standards of cleanliness to take care of those patients. But let me ask you this, and if you tell our audience, how do you prove malpractice? What do you have to show to us of your case to survive?
The definition of malpractice in Alabama is the use of reasonable care, skill, and diligence in treating patients. So if a doctor falls below the standard of care, we have to have, by statute, a doctor to come in who is similarly situated, similarly trained, practicing in that line and scope of practice within the year prior to the incident, and that doctor has to say that the standard of care, which is the same in Anniston as it is in Anaheim, California, and every place in between, has been violated. On the other hand, the doctor or the hospital will have experts who come in and tell the same jury that in their opinion the standard of care has not been violated. And then a jury made up of 12 citizens of this county has to take those competing opinions and decide for themselves which one is correct.
Now when you're pursuing a malpractice case, whether it's through a negotiated settlement or whether you actually file suit, does it matter which insurance company is representing that provider?
Does it ever? Most of the doctors in Alabama are insured by a company called Pro Assurance in Birmingham. It is run by one of the finest medical malpractice lawyers ever in the state of Alabama, Stan Starnes.
Yeah.
And they have essentially a practice and a policy that they do not settle cases because it promotes litigation. And so they do a terrific job for their insureds. That doesn't mean that there aren't some settlements, but by and large, all of the pro-insurance doctors in Alabama are essentially encouraged to defend themselves vigorously, and they do so, and they've got excellent lawyers. On the other hand, there are some hospitals and some insurance carriers in Alabama who want to have an early opportunity to resolve cases, and toward that end, I think there is something to be said for companies and hospitals that take that approach. I do think there is some goodwill being created.
I've run into this, and I've actually done this for some of the doctor clients. Doctor's got a problem. It could result in a big loss. He's got limits on his policy, and I have written the insurance companies to say, we demand you settle within the policy limits. Now, tell the audience why I would do that.
For 2 reasons. It protects your doctor. It honors the fact that he thinks he has made a mistake and does not want to have the case tried and have all the publicity that comes with that from time to time. But it also places the burden on the insurance company in case that case is tried and there is a verdict that is rendered in excess of that doctor's policy limits. It also promotes a discussion between you, the lawyer for the doctor, and the insurance company that is healthy, and that is, why do you think the case ought to be settled? Is it a case that we can settle reasonably? And if not, who is willing to bear the responsibility of a verdict that exceeds its coverage?
Puts the insurance company on notice that they may have an excess verdict question.
Absolutely.
Yeah, we've done that. Now, do you have anything you want to ask for?
I would just like to know what's the first thing that you do when you get a case that you think it could be good, but you don't know for sure?
The numbers speak for themselves. About 850 times a year, we can write a letter and resolve the issue with a potential client just based on our interview, our intake process. That leaves about 150 cases where we order records. That leaves 150 cases that have to be reviewed against the criteria or the bar that we have set. And most of the time, we do not get local review or outside expert review of those cases. There are times when we can pick up a phone and call a friend and know exactly what needs to be said. But of those 150 cases, about 10% of those are pursued. So you're now looking at 15 to 20 cases a year that are being pursued by a law firm that's spending a great deal of time and money looking at 1,000 cases. Those numbers are extraordinary. And so we have to be right in the intake process, and we also have to be transparent. We have to give doctors and nurses the benefit of the doubt, because most juries will.
And these cases can be very, very expensive.
They can.
To go through the process for, and you're paying for that. The client isn't paying for that.
We advance those costs, and I can tell you on average it's around $100,000 for us. We probably try more cases than most plaintiffs' firms in the state. And it's not so much that they're all that expensive compared to other cases, but they are expensive compared to the commitment that it takes to handle them. You've got to have experts on board in the beginning, so they are on board for the entirety of the time that the case is pending.
We have about 30 seconds. Can you give our audience some idea of the breakdown of where that $100,000 is necessary to spend?
Sure. It's typical for us to spend $25,000 to $30,000 to get the upfront review that we need. I cannot and will not file a case that I have not had reviewed and don't have an expert willing to testify on the standard of care. So that money goes out almost immediately. And then in preparing the case, we bring them for deposition and then to the courtroom, because we try many of these cases.
Okay, we're about to end our second segment. We'll return in a couple of minutes and we'll continue our discussion. Thanks for watching. Welcome back to our third and final segment of our show. We are having as our guest Mr. Leon Ashford, a longtime acquaintance and friend. He does a lot of medical malpractice cases, and we're going to continue our discussion with him. And we want to turn to the question of differences between death cases and those cases of patients who survive. And let's just assume that we've got medical malpractice. What difference does that make?
It makes all the difference in the world in the state of Alabama. We're the only state in the country where wrongful death damages are entirely punitive. We're the only state in the country where a local jury is told that in order to return a verdict against a local doctor or a local hospital in a death case, they must be willing to punish that doctor or that hospital or that nurse. And that is a big hill to climb in this day and time. And unlike in compensatory damage cases, the word punitive or punish is never mentioned. You set out and tell the jury in the beginning that you are here simply to get full and complete and fair, reasonable compensation for this plaintiff.
Well, let me go back to the difference or the definition of punitive damages. As you mentioned, it can only be awarded in death cases.
Correct.
In this arena. What does that mean what is the jury told is punitive? What are they supposed to bring back?
They're supposed to bring back a verdict which will preserve human life by punishing this defendant and by setting an example for others who, in similar situations and in similar practices, will be deterred from acting as the defendant did in this case. And it is a noble purpose, and it's a purpose that a jury will absolutely embrace if you've got the facts. And if we go back to the definition of malpractice, bad things happen to good people. And those are the kinds of cases where that is often a defense. People may be very sick, there may be a question about what caused their death, and you may try the case not so much on liability and whether or not the standard of care was breached or violated, but you may spend most of the time before the jury actually talking about all of the conditions that the patient had and brought with them into the hospital and what actually caused the death. And what I would say in Alabama that is really unique from other parts of the country is that the jury is told in cases like this that nobody is perfect No doctor has to guarantee the results. And more importantly, they're told that if there are alternative methods of treatment, that doctors are free to choose from those alternative methods as long as they are within the standard of care. So the jury charge to a local jury in Calhoun County or any of the surrounding counties in a death case is one that really pulls at their core to look at a doctor or a nurse and say, I'm willing to go back to a jury room and punish that person.
And if you have a patient who survives, it's when you get the compensatory damages
Correct.
to make up for their losses, pain and suffering, and that sort of thing.
Yes, and it's a completely different argument, as you can see.
Yeah, do you think it's easier to win one that's compensatory as opposed to one that's just purely punitive?
It depends on whether or not you reach the bar in both of those cases.
Of proof.
Of proof. If you can get the level of proof, I think generally after 41 years, it's harder to win a death case than it is a compensatory case. But I tell every injured client that I represent, the case is on your back. You have got to win this case yourself. You've got to be believable, you've got to be sincere, you cannot embellish anything, and you've got to go in there and hold your chin up and face up to the fact that the doctor or nurse on the other side is more likely than not going to get the benefit of the doubt.
Well, let's talk about instances of malpractice that are easy to understand.
Okay.
First one comes to mind is an object left in the body.
Happens less frequently than it used to. Most doctors and most hospitals now have to make an X on the knee that they're going to operate on or on the side that they're going to operate on. It does still occasionally happen. Medication errors are very prevalent these days. Not so much giving the wrong medication, although that happens, but we are seeing a number of cases that involve large doses of narcotics where people have conditions that affect their ability to breathe after they get the narcotic, and the nurses are not in the room, the family's not in the room, and when somebody walks in, the patient has had a respiratory arrest. Those are the kinds of shocks that it takes for a family to come into our office because they don't expect that. They do not, it's a death that is not predicted or expected.
And when, you and I recently had a case, we won't mention the name of it,
Sure.
involving a patient who died because there was allegedly not some medicine to counteract it.
Yes.
And that case was successfully settled. But what figured in the value of that? We talked about that. Talk about that a little bit.
Sure. Going back to what gets people in, if you go to a doctor and you receive an injection, the least thought in your mind is that the person receiving the injection would have an anaphylactic reaction and die on the spot. And people who give injections of medications in this country have to be prepared to deal with those kinds of consequences because they can occur. They're rare, but they can occur. And so it's a matter of preparation, but it's a matter of preparation in the hospital. It's a matter of preparation and process in doctors' offices and in any setting where you administer a medication. You've got to be prepared in this day and time for the complications that can occur. And so in that instance, what led to the settlement, I believe, is that we were able to get away from what happened precisely at the moment of the injection and go back and show that they had weeks and months and years to prepare and train and get ready for that terrible thing to occur. And yet there was no process in place that gave that patient under those circumstances a chance to survive.
If I remember right, there was no medication to counteract that drug, and there should have been.
No airway, no medication to counteract it, no laryngoscope to put a tube in her throat, nothing to do except, in that instance, to call 911.
Yeah, and I think if I remember right, the patient died by the time she got to the hospital.
Absolutely, she did.
She did. What are the typical defenses that the medical provider has in most of these cases? How do they defend them?
Most of the cases are defended. Let's just talk about cases that involve patients who might have more than one problem when they come in. Like they've got a cardiac problem and they're in for abdominal surgery, and there's an arrest. The question becomes what really caused their death. And most people do not consent to an autopsy in that setting. They just don't want to put the patient through it.
Well, the family through it.
The family. And yet, the best thing I could say to a family who has an unexpected death occur is ask for that autopsy. The only way you will ever know what caused that death for sure is to have the autopsy done. But in the setting that we are talking about, where there is something unexpected, something that you do not know is likely to occur. Now, many people die when they're just very sick. But if you are in for an elective operation and you get a bad result and there is a patient death, the absolute safe thing to do
Autopsy.
is get an autopsy.
Now, every bad result is not malpractice.
Not even close.
We have about 30 seconds left. Remy, you want to ask the final question?
Well, I mean, I don't think we're going to have time for what my question was going to be, just because it would be.
Well, do you have one?
Nothing that won't. I think we're going to have to bring him back for a.
Okay. Well,
for a
Leon's
second show.
agreed to come back for another show, hopefully, maybe in the next few months. Any parting words? We have about how many? 15 seconds.
Yes. Come to people that honor and respect the medical profession and will answer your questions. And I think that this whole situation handles itself.
All
when
right.
you do that.
I think that's great advice. Thank you for watching, and we'll be back next week.